Welcome guys. This is going to be a summary video for Unit 2, Area Study 1. So we're going to be looking at civil liability, the first topic in this video. Just a reminder, as you're watching the video, I highly recommend taking some notes as you go to help you memorize the content. And in terms of preparing for your SAC, what you want to make sure is that you're using this key knowledge checklist as a guide. So you want to try and make sure that you know these 4 areas in as much detail as possible, because you could be asked a question about any of these 4 particular areas here. Alrighty, so moving on to what we're going to be looking at in this video is we're going to be looking at the purposes and what are the different types of civil law. What are some of the key concepts known about in civil law? So for these ones here, generally you've got to know a really clear definition and how to apply it to a case. And then lastly, we're going to have a chat about a couple different plaintiffs and defendants in a civil dispute. So moving forward, it's really important that as we're starting a new unit, we just go back and refresh our memory on what's required of these task words. So just remember some task words like distinguish, for example. If you get asked to distinguish 2 things in a question, make sure you're stating a really clear difference. Another common mistake I really see is that if you get asked a discuss question, which is really likely on this SAC, make sure you're considering both sides. And what I mean by that is considering both strengths and weaknesses, limitations and that sort of thing, how something's effective, how it's not effective, but just be really clear that you are talking about both sides of an argument or both sides of the discussion. So I'll leave this up here. Just make sure that you have a clear idea about what's required about these words, and then you can't really mess up on the questions that you are asked. Moving on. So when we look at civil law, it's really important to know that it's involving 2 individuals or groups. And the biggest difference between this and criminal law, it's about where people's rights have been infringed. So for example, your reputation has been damaged, someone's failed a duty of care, but your rights have been infringed and some kind of loss has occurred as a result. So what's really important to know is that when we are suing someone or when we are taking civil action against someone, what we're trying to do is we're trying to get us to where we were before the wrong was done. So if you've suffered some kind of loss or something like that, what we want to make sure is that by you taking civil action against someone, you're trying to be back before that physical harm occurred or before you lost those wages, whatever it might be. So what it's trying to do is trying to recognize that your rights have been infringed upon, and your ability to sue is hopefully going to get you back to where you were before that wrong occurred. All right, moving on, we have 4 purposes of civil law that we need to know. So generally speaking, you can't be asked about all 4. So what I would suggest is remembering just 2. 2 will give you a really good base point to start with, and then having a third one as a backup. But remember 2 in detail and what they mean and perhaps how to apply them to particular cases you might get. So number 1, purposes of civil law. It's pretty straightforward, as you guys would have plenty of rules and laws in your lives. The whole idea about civil law is it provides guidelines for acceptable behavior. So basically making it really clear what is right and wrong. And I guess the whole aim of having really acceptable guidelines about what is right and wrong is we want to make sure we achieve social cohesion. And what that means is we're living in a society where we have peace and harmony, and we don't have people's rights being infringed. We don't have people, committing civil wrongs or torts against other people. So similar to criminal law, pretty straightforward there. Second one, we obviously want to make sure for them to be effective, we want to make sure they protect the rights of individuals. And how we make sure civil law protects the rights of individuals is that we actually embed the rights in laws. So if they are physically written as laws, such as, for example, the Wrongs Act, for example, is an example where you might find laws, it means that by them being embedded into civil law, people can realize that if they do break those laws or they breach your rights, there will be consequences as a result. So for example, if someone damages your reputation, they are committing the tort of defamation and they can face consequences as a result. But it's really important that you understand that the reason your rights are so protected is because we have physical laws that stand in place to protect us. Moving on to the third one, this one's a really important one, because what we need to make sure that is if someone does infringe your rights or someone does do the wrong thing by you, we want to make sure that you have a place to go to get it resolved. So if someone has infringed your rights, we'd ideally want you to get compensation or some kind of recognition that a breach or a loss has occurred. And what's really, really good about civil law is that you don't just have to go to courts. We have tribunals, we have complaint bodies, we have mediation, some things like that. And what's really good about those is there's lots of different ways we can go and access methods to help us resolve our disputes. But we want to make sure there's lots of help available, whether that's advice or a formal place to get it resolved. Really, really important part of civil law is that we can have a place to go to get our case resolved. All right, and the lucky last one is obviously really, really important, is that we want to get some sort of remedy or some kind of compensation if the court recognizes that harm has occurred. So if you have actually been harmed, someone has done the wrong thing against you, we really, really want to get you back to where you were before that breach occurred. So what we mean by remedies, our most common one, like I've got there, is what's known as damages, but we also might have something called an injunction, and that's going to maybe stop someone from posting, defamatory material about us online. But we want to make sure that someone does do the wrong thing against you, we can put in place a really effective consequence where it's going to sting them and make them realize what they've done was wrong. All right, moving on to our next one. We have 4 types of civil law that you need to be aware of. There obviously are many more than 4, but I'm just going to be focusing on probably the 4 most common types of civil law that we see in Australia. So first one, negligence, where someone sort of fails a duty of care. Second one, trespass, interfering with someone's property. Defamation, where we've got someone's reputation being damaged. And finally, nuisance, so damaging or destroying someone's quality of life through noise, smell, that sort of thing as well. In the sake of preparing for this SAC, we are going to be deep diving into negligence and defamation in the next couple videos, so stay tuned for those. But just be aware about what these 4 main ones are and how they are relevant to civil law. So, moving on, this is probably one of the more complex areas of this particular topic. We need to have a really clear definition of several different areas of civil law. So if we go back to this one here, what we need to make sure we know is we need to know a clear definition of these concepts here. And we really want to be prepared by knowing how to apply them to a particular case. So, in a case study, can we identify the loss that has suffered? Can we identify which party has the burden of proof? So my advice for this one is get some flashcards or some cue cards, whatever works for you, and get a really clear definition of each of these down, because chances are you'll be having to apply them to a particular case study. So moving on to our first one is the breach. So what's really just straightforward about a breach is that we need to prove that the defendant has done the wrong thing. And by breach, we want to prove that someone has failed to follow by a law or obligation, and as a result have caused some kind of harm. So in the example I've got here, it says 5-star hotel held liable for the drowning of a Chinese tourist in a pool. This particular lifeguard at this hotel was not a trained professional, and someone drowned as a result. So therefore the hotel would be found liable as they have breached their duty of care. They've done the wrong thing. They've failed to observe a law or an obligation. And as a result, we can see that there has been harm occurred. So breach, basically think about someone has done the wrong thing or they've failed to follow a law. Moving on to the next one, it's really important that, when we're comparing criminal and civil law, we need to remember that the plaintiff has the burden of proof. Make sure you try not to get words like prosecution into looking at civil law. And what we need to remember is that the plaintiff, they have the responsibility. So if you're choosing to sue someone, if you think someone has done the wrong thing by you, you have the responsibility as a plaintiff to bring forward all that evidence to prove that the defendant did the wrong thing, to prove that the defendant broke the law, for example. Moving on, when we have the standard of proof, it's a lot lower. The standard of proof is basically saying which side is more correct. So you'll remember from criminal law, we talked about that if we want to charge someone and find them guilty, it has to be beyond reasonable doubt. We can't have any doubt in that mind that that person is guilty. In civil law, it's significantly less. So we only need to prove whose story is more probably correct. So if you think of it like a scale, if it's slightly tipping towards one party, they're the one who's going to be found in the right. So it's very a little bit different in terms of proving someone liable of a crime. All right, and moving on to our next one. With our next principle, we have what's known as causation. So the easiest way I'd recommend remembering this particular concept, because it's probably one of the more confusing ones, is it is basically, think about it like a chain. When we have any issue of civil law, we want to prove that there is a connection or a link between two things. So by causation, we got to prove that the defendant's actions over here resulted in this person getting harmed, for example. So we want to be really, really clear that there is a connection or a link between that particular consequence. So it's known as what's known as a causal link. So for example, going back to that drowning case study on a couple slides ago, we want to prove that the hotel's failure to employ a suitable lifeguard was the direct result of that particular person drowning or getting harmed. So really, really straightforward when you think of it like a chain. If there is a break between the chain of causation, it means that person can't be held responsible. So for example, if we go back to that slide of this example here, if it turned out that they did have a lifeguard who was trained, but the tourist decided to swim when the pool was closed, then that would be a break in the chain of causation. That would mean the hotel was not responsible. So just thinking about that, they were the direct result, or there was a direct link between action and consequence. Moving on to the next one, limitations of actions. So what limitations of action means is that we generally put a time period, or we have something in place as to how long you have to sue or bring action against someone. And I guess the reason why we do have that in place is that over time, the quality of evidence goes down significantly. Witnesses can forget things, people can die in cases, that sort of thing. And also parties need closure. So for things like defamation, you only have 1 year to initiate civil action if you want to sue someone. And things like under particular tort laws, like workplace injury, you only have 3 years. And I guess what I've got here, the most important thing is that we want to make sure that disputes get resolved quickly. And we want, to make sure we have the best reliability in terms of evidence. So ideally, if something is gone wrong, we get that resolved straight away. Evidence is still nice and fresh in the witness mind, in the plaintiff's mind, in the defendant's mind. So that way we can get it resolved nice and quickly. And the last concept we have to know is what's known as a loss. So this one is probably one of the more straightforward ones, but a good way to think about loss is damage, detriment, or suffering flowing from the act or omission of another. So what that means is that loss is some sort of damage that has occurred as a result of someone doing a particular action, for example, some sort of workplace injury, or not doing something, failing to supervise someone and them getting hurt as a result. That's known as an omission. And just remember that in civil law, when a civil law case does go to court, they're going to be probably claiming a variety of different losses. So common ones, for example, if they've suffered like a workplace injury, they're going to want to need to pay for their medical expenses, such as x-rays, ultrasounds, follow-up special appointments, but they've also may have lost some wages, so their income not being able to work. But just remember, in particular, in terms of like a workplace injury, they might have ongoing mental health issues and anxiety as a result. So if they suffered a machine-related incident at work, they might be really scared to work around machines in the future and need some compensation in that area. Or they may have suffered a permanent disability as a result of a injury at work, and they've now got a loss of enjoyment of life. So I guess just remember, it's important to know that there are lots of different types of losses. And the chances are you're going to be getting a case study where you'll have to pull out maybe 1 or 2 different types of losses that particular plaintiff has suffered. But just be aware that there are many different types of loss that people can suffer. All right, moving on to the last part of today's video is the possible types of plaintiffs. This is really, really straightforward. Just remember that, the main plaintiff is going to be known as the aggrieved party. This is the party whose rights have been infringed. So the aggrieved party might be the person who had defamatory material posted about them, and they've obviously suffered some kind of reputational loss. Secondly, we might have other victims. So this could be something like seen at a workplace machinery incident. So if your colleague or your friend at work gets seriously injured, you might have indirectly suffered a loss. You might have indirectly suffered some trauma as a result of that, shock of seeing an event happen in the workplace. But I guess just remember, in most instances, you're just going to have the one plaintiff, which is the aggrieved party, and this is the person whose rights have been infringed. But in some situations, there can be other people who are indirectly, influenced by particular things. With the defendants, we've got 3 defendants to look at. So the wrongdoer is the person who directly caused that loss. So for example, the person who posted defamatory or hateful material about a person online, that's the person that has caused loss to that defendant, that plaintiff. Second one, there can also be employers. So employers are extremely responsible for their employees. So because of a principle called vicarious liability, if you own a company, for example, and your employees do the wrong thing, you can actually still be held responsible for their actions as well. So obviously within reason, but it's important to know that, employers are definitely responsible. They're responsible for training their employees regularly, making sure they do regular things like first aid training, how to safely handle equipment correctly. And if they fail that, they can also be held responsible. And lastly, we have other persons involved in the wrongdoing. So obviously we might have like the main person who was a part of the defamation case, but just remember that there also can be people that have aided, abetted, or procured in the wrongdoing, and they can be kind of held a little bit responsible as well, which is really important to know. All right, just to wrap up, just remember, like I mentioned at the start, I don't have it here, but remember your task words are everything in legal studies. So I really suggest you make sure you know what each of the task words are asking you, like explain, distinguish, and discuss. Because if you can nail that skill in year 11, it makes year 12 significantly easier. Just to recap, there are 4 purposes of civil law that you need to be aware of, but I recommend remembering 2 to 3. You can never generally be asked about all 4, so keeping 2 to 3 will keep you safe. Secondly, with the main aim of civil law, I want you to keep this in your head for the next topic as well, that when someone does the wrong thing by us, or when someone infringes our rights, we really want to make sure that we get back to the original position before our rights were infringed, or before that person has wronged us. And lastly, with the key concepts one here, I just want to remind you guys one last time is that, as you can see, you've got quite a few key concepts here to remember. Make sure you have a clear definition of each, and also be able to apply them to a particular case study, and then you'll be all fine for these first 3 key knowledge areas. I'll see you guys in the next video. Thanks for watching.